May it please the Court? I'm Patrice Talisman on behalf of the appellant, Carol Smith. With me is Greg Silverstein. This is an appeal from a final judgment rendered in accordance with a jury verdict. There are three reasons why we believe that this verdict and judgment should be overturned and a new trial granted. First, the lower court refused to allow rebuttal evidence that refuted one of the defendant's main theories. Second, the lower court refused to instruct the jury on one of plaintiff's theories of the case. And third, the court refused to allow in evidence that defendants had changed their method of operation after the defendants opened the door to such evidence by presenting testimony that there had been no similar incidents in the 6 years since Ms. Smith's fall. Since I only have 10 minutes, I'm not sure I'm going to make all three arguments. If I don't think that I don't like that argument. But
I think your strongest argument is the jury instruction on the premises liability.
Let me start there then, Your Honor.
I frankly don't buy the other two, so go ahead.
Well, I'll start with that, and then we'll talk about everything else if we have time. The lower court, as to SMG, we specifically requested both that there be an instruction on negligence and how they led the crowd or they controlled the crowd, and also premises liability instruction. The law is well established that plaintiff is entitled to have the jury a party is entitled to have the jury instructed on all theories of their case, and that the court commits reversible error if the requested instruction refuses the requested instruction and accurately states the law, it's supported by the evidence, and the instruction is necessary to allow the jury to resolve all issues.
But the real question here isn't it, is how the premises liability really fits with what SMG's role was. They're managers of the property, not owners of the property.
But they are in possession and control. It was admitted that, in fact, they were the ones who were there, and in fact, the city's entire defense to this was, we weren't there, we had nothing to do, it was all SMG. So, and they're all being defended by the very same attorney. So at trial, SMG is saying, essentially, you know, if anybody's at fault, we're the ones at fault. We are the ones who were in possession and control. The city didn't have any employees there. The city had nothing to do with this. So clearly the question of premises liability is who is in possession and control. It can be the landowner, it can be the maintenance company, it can be both of them. So I think clearly as to SMG's role, there is evidence as that. It wasn't disputed at trial. As to the issue itself, defendants have said on appeal, well, there wasn't any evidence to support the giving of the instruction, but that simply isn't supported by the record. Mr. Jacobs, plaintiff's safety expert, expressly testified without any objection whatsoever that the landing into which the escalator leads in this theater is a confined area.
The other side's claim is it was an operational type of control, and that there really wasn't anything. It was a crowd management problem, not really a dangerous condition of the. I know about the landing, but their argument that seemed to have won, and there appears to be some logic to it, as that it really didn't have anything to do with the premises itself. It had to do simply with the management of the crowd.
It's the two things together. And when it is the two things together, the Florida courts have in fact recognized that you get a premises liability instruction. You've established a dangerous condition. One of the cases that we've cited is Paul versus Sea-Watch, where they were in a bar and sitting on a high stool that was next to an elevated stage, reaching over to give money to one of the dancers in the stage. And the court said, well, look, just because it's elevated and there's a high stool, this clearly isn't a defective premises. You know, this is simply a nice, normal bar. But when you combine that with the policy of allowing the customers to drink unlimited amounts of alcohol and to interact with the dancers who are up in the stage, then you have a dangerous condition of the premises, and summary judgment in that case was improper. Maybe but that the two combined, the method of operation along with the premises arrangement, was in fact sufficient to create a question of premises liability. Florida Supreme Court has made clear method of operation is in fact can be used to establish premises liability. Markowitz.
So what was insufficient with respect to the premises here?
The way that it was arranged in conjunction with the crowd, so that the escalator led out into a confined area. And the expert expressly testified, having an escalator deplane or disembark into a confined area is an unreasonable hazard with a crowd. And he went on and said the reason it's unreasonable is because of the possibility of the slip and fall. And the other point that you get to is not only is it a dangerous condition, but part of 3.5F is you have a duty to correct, you have a duty to maintain in the first place, but also you have a duty to warn. And in this case, once again, it was SMG's and the city's defense that SMG didn't do anything to create the backup. And that may have been, and the jury may have had the right to find. I mean, certainly that was a contested issue. But whether or not SMG did anything to actually create the backup that formed at the time that Ms. Smith fell, if they had a duty to warn of it, that question is actually irrelevant. Because if it's foreseeable that the backup would be created due to their method of operation, then SMG has a duty to warn the teachers of it. And if Ms. Smith and the other teachers had been warned of it, they could have taken actions to prevent this from happening. Ms. Smith could have let the other classes clear before she led her class onto the escalator. The other teachers could have been quite clear that no, we have to keep moving. If it was the teacher's responsibility, and if it was their fault for a backup, they would have known why it was important, and in fact moved these students away. But the jury was never told that as to SMG, who is the defendant who had the employees there who would be giving the warning. So in fact, it is very, very important that that issue have been presented to the jury. We requested it, presented evidence on it, and the court failed to instruct on it. This court just...
Was there a claim for failure to warn made in
Yes.
the complaint?
Yes, Your Honor, it is. And actually, I have that right here. If you look at the amended complaint, let me just get to it.
I accept the representation, Ms. Townsend.
It really is. And if you look at it.
Not a difficulty.
So that's why it's important. This court just recently in Moss versus Country Kitchen held that when you limit the jury's consideration of the issues, and in that case it was limiting the jury's consideration to how coffee was carried by a waitress rather than the operation of the restaurant, that was in fact reversible error. That's exactly the same thing here. We alleged other types of negligence than simply crowd control. We were entitled to have the jury instructed on that. I haven't really been watching my time. Do I have time to address any other issues?
You have a couple of minutes. You want to briefly address?
Let me just go on the rebuttal, because I think the rebuttal issue is also important. We presented testimony from 3 board-certified surgeons, orthopedic surgeons, who all said that the injuries for which, or the conditions for which they performed surgery on Ms. Smith were caused by this fall and the children falling on top of her. Defendant's only witness on this subject was a radiologist, and his testimony was very clear. By looking at the MRIs, and only looking at the MRIs, knowing nothing else about this case, these injuries, these same injuries, were not caused by the fall.
Yeah, but didn't I think it's Arena, didn't he in fact testify that an MRI is simply a diagnostic tool and that the treating doctor is in the best position to evaluate the patient? So didn't he essentially testify to what Dr. Konigsberg would have testified to?
Well, actually, Dr. Konigsberg was their expert.
I guess I have him reversed.
And he said and he did say, it's not perfect as to diagnosis, and then he said surgery isn't perfect. But it's not really a question of diagnosis. We're not contesting that Dr. Konigsberg said this is or isn't a herniated disc. The point is that Dr. Konigsberg said, I can tell just by looking at the MRI that this herniated disc or this bulging disc was or was not caused by the surgery. And none of the other witnesses.
But then he also follows it up.
He did.
This is just a diagnostic tool, and obviously the treating physician
But not
is
as
in
to
a much better
causation.
position.
But he didn't limit it in any way as to causation. There's a difference between diagnosis. There's a difference in saying there's a herniated disc versus there's a bulging disc. And whatever this condition is, it was caused by the fall, or it was a degenerative condition, or it was caused by another accident. Dr. Konigsberg never in any way modified his opinion, I can tell causation just by MRI. No one else ever testified to whether or not you can tell causation by MRI. The surgeons certainly didn't do so. Everybody did, in fact, talk about diagnosis. You know, what do you see on the MRI versus what do you see in surgery, what that condition is. But they didn't address whether or not you can solely use MRI as a diagnostic tool. And that's what Dr. Arena would have testified to. Now, it's true, he may have Other things may have been proffered, but certainly that point was made very clear in his testimony, that no, you cannot tell causation simply by looking at the MRI. You have to also consider the history. And to the extent that we were attacking the methodology that he used, this court in Zanilotti, the 4th TCA in Griefer, 4th TCA in Wax, all of the courts have held and made it very clear that when you're attacking the methodology that's used, A, that's very important evidence because it's what needs to be given to the jury to consider the weight of the testimony, and B, it's absolutely proper rebuttal, and it's an abuse of discretion to deny the introduction of it. So for those two reasons, as well as the third argument made in the brief, we would request that a new trial be granted.
Good morning. May it please the Court, my name is Brett Powell, representing the appellees here. I'd like to start with and dispense with that last point first.
Well, I'd prefer you start with the jury instruction point.
Yes, ma'am. Certainly. As to the premises liability instruction issue, we take no issue with the appellant's contention that if the evidence adduced at trial creates an issue, then the party has the right to have the jury instructed on that issue. The fact in this case is the entire thrust of Smith's case, and in fact everything that her expert stated, was simply that the appellant never or did not properly control the crowd here. They did not and never argued the elements of the premises liability, that being that the building was
Didn't they in fact argue that they had a duty to warn? Wasn't that a part of the trial below?
Your Honor, I think Smith's expert says it better than I can. The failure here again was SMG management to keep a smooth flow of traffic. They allowed the situation to become crowded. Someone had stopped that group from continuing to flow. They failed to basically maintain the escalator's free flow. That was the problem. That created a backup. If that would not have happened, they would have been able to safely use the escalator. Their expert stated that himself, that the only issue before us was SMG's failure to take these children and move them through up the escalator and down the hallway in a proper fashion. They did not argue that there was a failure to warn, or they did not present evidence to say that there was a failure to warn. They did not present evidence that said that there was a failure to modify a hidden dangerous condition. In fact, the trial court here specifically engaged plaintiff's counsel and asked him, well, tell me, what is the evidence? Show me the evidence. Who said what that justifies this premises liability instruction to SMG? Plaintiff's counsel could not give an answer. He could not point to any evidence. And the reason why is there simply wasn't any. The court specifically said, there is no evidence in this case that anything was wrong with the premises, that it was maintained or anything was wrong with it, like the escalator didn't function or whatever. Plaintiff's counsel interrupts and says, no. But arguably, to have 21 or 22 people on each step every 17 seconds in a very confined room, that arguably is too small an area. The court says, well, wait a minute. No. No one has said that. No one testified to that in the trial. The plaintiff's counsel said, but it's argument, I think. The answer is no. The argument has to be supported by the evidence. They claimed it. There is a count in the complaint, but there is no evidence adduced at trial to demonstrate a breach of the premises liability count. There was no testimony regarding negligent maintenance, no testimony regarding a negligent failure to correct a hidden danger. There was no evidence that they should have warned anyone. The only negligence was that they should have controlled the crowd better and that they actively caused this backup. I'd like to point out one factual dispute that we have here, and that is plaintiff's counsel, both at trial and on appeal, characterizes this area as a very confined area. In fact, their expert referred to it as a confined area, but referring it to us that way doesn't make it so. The evidence here is undisputed. You come up the escalator, there's a wall to your right, there's a wall to your left, you turn to your left, and there is an open hallway. You have to go around a pillar and down the hallway. But nowhere is there an obstruction. Nowhere is there a confined landing. You simply proceed through the hallway. There's no hidden danger here. There's nothing that anyone couldn't see on an escalator that they don't know about an escalator to begin with. It's not a hidden or unusual danger. There's nothing concealed here that the average person or an individual would not understand. As this court said in the Olson case in 1990, quote, An owner is entitled to assume that the invitee will perceive that which will be obvious to him upon ordinary use of his own senses, and is not required to give the invitee notice of a warning of an obvious danger. In other words, you don't have to put a sign up by the escalator that says, if you put too many people up here and nobody walks off the escalator, there's going to be a crowd form. That's not their requirement. And in fact, plaintiffs never argued that it was. Now for them to come back and say, well, we should have been able to have this premises liability count, which was in fact given to the city, as to the city, simply just tries to take from the jury their right to weigh the evidence that was actually presented to them and reach their own verdict. If I may proceed to the rebuttal point. For the very reasons that Ms. Talisman stated as to why, as to what the evidence in this case adduced, is the very reason why this rebuttal was not appropriate. As she stated, 2 of Smith's own experts had previously stated precisely what Dr. Arena would have said, that MRIs are not definitive diagnostic tools. They're not intended to be definitive diagnostic tools, and it's the treating physician who's in the best position to say what the diagnosis is. In fact, Dr. Stephen Winder continually referred to first-hand observation as the gold standard of diagnosis. This was entirely cumulative to what those 2 doctors had said. In addition, it was entirely consistent with the concessions that Dr. Koenigsberg, the defense's expert, had made when he said the MRI is not the perfect diagnostic tool. And yes, he would defer to a treating physician for their diagnosis. The only other basis they had to try to get this supposed rebuttal testimony forward is that there were areas of the body that were not scanned by the MRI that Smith claimed to have injuries, for which Smith claimed to have injuries. The trial court asked, well, did anyone ask Dr. Koenigsberg about that? Did he testify to it? And the plaintiff freely admitted, no, I never asked him. In fact, he said, well, I didn't know that then. I know it now. I didn't know it then. That's not rebuttal. That's an attempt to reopen your case, to put evidence in that you should have put in your case in chief. The trial court didn't abuse its discretion in refusing the rebuttal testimony. It didn't abuse its discretion in the premises liability count. And for the other issue, which I don't have time to address, the trial court did not err either. And so we respectfully request that this court affirm the final judgment entered pursuant to the jury's verdict. Thank you.
Counsel, we'll give you another couple of minutes.
Thank you. I really appreciate it. The argument that we didn't argue premises liability, we didn't present evidence, again, it's contradicted by the record. Plaintiff's expert, pages 437, 38, 441, 467. Is there a danger because of an escalator taking people up to a confined area? Yes, there is a considerable danger. What is that danger? It's backup problem. People then encountering each other can trip, slip, fall. SM management knew, or they should have known, that since you have groups of people coming in here and making these observations of previous work there, that these backups could occur. It was an unreasonable hazard. They knew or should have known through inspection that the backup crowds can produce fall hazards on the escalators, which I consider to be an unreasonable hazard and, again, foreseeable. Exactly the language of the premises liability instruction. It's a dangerous condition. Pages 1142 and 1143 of the transcript, when the judge asks, okay, what's the testimony? In fact, Mr. Silverstein says, Mr. Jacobs addressed that. He said that it was an unreasonable hazard. It's not a confined area. Their own expert at page 971 of the transcript admits that it's a confined area. It's not an obvious hazard because, as everybody admitted, including their own employees, you cannot see the landing and the crowd when you get on the escalator. This was, in fact...
What was the jury's verdict as to the City of Miami on the premises liability count against them?
The basis was defendant's argument that the city wasn't there. Oh, they said no negligence. They said no negligence as to both of them.
The city was not guilty.
The city was not guilty of any negligence, and their argument was the city wasn't present. The city had no employees there. They gave everything to SMG to do, so the city had no responsibility whatsoever.
The instruction was given as to the city?
Yes, it was. But again, their response was, well, if anybody had anything to do, it was SMG. It wasn't the city, and the instruction wasn't given as to SMG. On the rebuttal, the only point is it's causation. The question really is causation, not what the diagnosis was of the condition, but causation, and no one else testified to that. Thank you so much.